So the ruling is in respect to the application dated 1st December 2024, wherein the respondent applicant, that is Enock Okero, seeks the following orders. That pending inter partes hearing and determination of this application, the court be pleased to suspend the orders. I think that one has been spent. The main prayer is that the court be pleased to set aside, vacate, vary, and discharge the orders granted ex parte on 29th November 2024. There's also the prayer for costs. I have considered this application together with the response made by the ex parte applicant through the replying affidavit of its acting clerk, Mr. Duke Onyari. I've also considered the further affidavit that was filed by the respondent applicant hearing. I've further considered your respective written submissions. I find that the main issue for my determination is whether this court can vary or set aside the orders granted on 29th November 2024 as sought by the respondent applicant. The power of the court to review its own decision is provided for under Section 80 of the Civil Procedure Act and Order 45, Rule 1 of the Civil Procedure Rules, which I've highlighted in this ruling. I note that the impugned orders granted the ex parte applicants leave to institute judicial review proceedings against the respondent, which leave was also to act as a stay of the impugned gazette notices. So in the case of judicial Commission of Inquiry to the Goldenberg Affair versus Job Kilach, the Court of Appeal considered the issue of setting aside of ex parte orders. And the court held, and I'll quote in part, I have said ex parte orders are essentially provisional in nature. They are made by the judge on the basis of evidence and submission emanating from one side only, despite the fact that the applicant is under duty to make full disclosure of all relevant information in his possession, whether or not it assists in application, whether or not it assists his application. This is no basis for making a definite order, and every judge knows this. He expects at a later stage, to be given opportunity to review his provisional order in light of evidence and argument adduced by the other side, and in so doing, he is not hearing an appeal from himself and in no way feels inhibited from discharging or varying his original order. This being the case, it is difficult, if not impossible, to think of circumstances in which it would be proper to appeal to this court against an ex parte order without first giving the High Court judge an opportunity of reviewing it in light of argument from the defendant and reaching a decision. End of quote. And similarly, in Republic versus Vice Chancellor Moi University and three others, ex parte Benjamin J. Gikenyi Magare Omondi J, as she then was, held as follows when faced with a similar application to vacate stay orders issued in a judicial review application. And I quote, to request the court to relook at the background leading to the issuance of stay is, in my view, not asking the court to sit on appeal on orders of a court of equal status. It is simply telling the court to reconsider the orders issued in light of the fact that the beneficiary of those orders concealed or did not disclose all the material facts prevailing. All the other issues raised will be better addressed at the hearing of the main motion. End of quote. My understanding of the above decisions is that the court's hands are not tied when it comes to reviewing ex parte orders made in JR proceedings. This is to say that the law permits the court to vary its decisions, particularly where the circumstances warrant review variation, such as where the ex parte applicant has concealed some facts which may have been relevant in making a decision at that preliminary ex parte stage. I find that this court has the jurisdiction to hear and determine the application for review and grant any suitable orders, even if the applicant may have already filed a substantive motion. So in this case, it was not disputed that this court issued conservatory orders on 11th October 2024, directing the parties to maintain status quo until the hearing and determination of the application in the petition at Nyamira in number A008 of 2024. To my mind, the effect of the conservatory orders was to stop any subsequent action against the holder of the office of the Speaker of the County Assembly, including his removal by way of impeachment. Flowing from the above position, it is clear that the applicant respondent, so the ex parte applicant in this case, did not disclose the existence of the conservatory orders in petition E008 of 2024 when they appeared before the court at Kisii on 29th November 2024. It is clear that they did not disclose the existence. Sorry, I'll take that again. It is also clear that they did not disclose the existence of the earlier judicial review case that they had filed in JR E005 of 2024 over the same subject matter, being the impugned Gazette notices. It is therefore clear to this court that the court granted the orders of 29th November 2024 without the benefit of the full set of facts and the background of the case from the applicants.
In view of the foregoing, I set aside
the effect of the leave granted here in operating as a stay of the impugned Gazette notices automatically conflicted or contradicted the existing conservatory orders. It is on this basis that I find that it would have been prudent for the applicants to disclose all material facts to the court to enable it to make a proper decision. Failure to disclose all the material facts paint the applicant in bad light and portray it as a party that was driven by mischief intended to circumvent the judicial process that was already in motion. The ripple effect of the impugned orders, as has been seen, is the embarrassment caused on the court with the ensuing confusion arising from the conflicting orders. This is a very untidy situation created where, on one hand, the Speaker has conservatory orders to continue with his work, conduct his duties, which include issuance of Gazette notices, and on the other hand, the Gazette notices are put on hold following non-disclosure of material facts. I've referred to the decision in Kaluma versus NGO Coordination Board and others. where the apex court, that is the Supreme Court, outlined the circumstances under which it could review its own decisions as follows. 1. Judgment, ruling, or order is obtained through fraud, deceit, or misrepresentation of facts. And 2. Judgment, ruling, or order is a nullity by virtue of being made by a court which was not competent. 3. A court was misled into giving judgment, ruling, or order under the belief that the parties had consented. And lastly, judgment, ruling, order was rendered on the basis of repealed law or as a result of deliberate concealment of statutory provisions. My finding is that the circumstances herein fall under the first scenario, where the court issued ex parte orders based on misrepresentation of facts or lack of full disclosure. This therefore calls for this court to review its previous orders. There was also the issue raised over the sub judice doctrine. I note that it was also not disputed that the applicants had previously filed JR number E005 of 2024, wherein they sought to quash the Gazette notice. The Gazette notices numbers are highlighted there on the basis that the respondent had issued them after he had been impeached from the office. I find that even though the applicants argued that the said JR did not challenge the third Gazette notice, such an argument does not vitiate the fact that they filed two similar applications at different times in respect to the same subject matter. The substratum of those two JR matters is primarily to nullify any Gazette notices issued by the respondent applicant hearing after his alleged impeachment. In other words, I find that JR E007 was filed after JR E005 in contravention of the sub judice ruling. I have also considered the applicant respondent's claim, the ex parte applicant's claim, that they had withdrawn the JR E005 of 2024. I find this claim was not proven because it is stressed judicial review proceedings may only be withdrawn with the leave of the court. In this case, it has not been shown that the court granted the applicant's leave to withdraw the said JR. It is my finding that the filing of multiple suits with the intention to obtain favorable outcome did not only amount to an undesirable act of forum shopping, but also constituted outright abuse and a mockery of the judicial systems. I've referred to this court decision in Purity Mora Kirera versus the Senate and 8 others, that was petition number 4 of 2024. For the reasons I've stated in this ruling, I find that the respondent applicant has made out a case for the setting aside of the orders issued on 29th November 2024. In the final analysis, I allow the application in the following terms. The ex parte orders granted on 29th November 2024, specifically in respect to the staying of the Gazette notices, are hereby set aside. Since this is a public interest matter with pending petitions and other cases, I make no orders as to costs. That is the order of the court.
I'm most obliged, my lady. If I have understood the court ruling correctly,